Welcome everybody to D&B's 5-minute briefings. I'm Neil Ishwood, an SME and strategy leader in our third-party risk and compliance line of business. This is part 2 of our briefings looking at the Economic Crime, Transparency and Enforcement Act and the knock-on effect it has to ultimate beneficial ownership information. So in this briefing, we're going to concentrate on the Register of Overseas Entities and the Companies House reforms. As of the beginning of August, the Register of Overseas Entities went live. After about 6 weeks, the register stood at nearly 500 companies, of which the British Virgin Islands and Jersey accounted for nearly 70% of those records. The reforms in this area continue to close down the ability for the UK to be used to launder and hide vast amounts of money, specifically in the property market. Previously, an overseas business registered in a jurisdiction with weak transparency rules could own property, and hence the real identity of who ultimately owned it was obscured and unknown. To close this down, these entities must now register at Companies House and declare who their ultimate beneficial owners are. Otherwise, they cannot be entered onto the land register, effectively blocking them from legally owning the property. There are a number of parts to ensure everything is verified and loopholes are eliminated. Firstly, the information on UBOs must be verified by an agent who will need to conduct ID and verification procedures. And these agents must be UK-based and supervised under the money laundering, terrorist financing and transfer of funds regulations. So this will include such entities or people as credit institutions, financial institutions, trust and company service providers, etc. To be able to carry out these checks, the agent must obtain an agent assurance code. Otherwise, it cannot submit information to Companies House to register an overseas entity. These agents can either verify the information and submit the relevant forms to Companies House, or carry out just the verification and then let the overseas entity itself register the details. But in this second case, the agent must fill out a form and submit that directly to Companies House to show independently that they did the verification. Once all this has been completed, the entity is registered and receives a newly created OE prefixed number. Once this number is obtained, they can then proceed with registering the property with the Land Registry. This will apply retrospectively to overseas entities who bought property or land on or after the 1st of January 1999 for England and Wales and the 8th of December 2014 for those in Scotland. And leaving arguably the biggest change until last, the proposed Companies House reforms. These will be the largest changes to the register since its inception in 1844. Currently, Companies House is legally obliged to place on the register any information that is correctly supplied. And the note there is not that it is actually correct, just that it is supplied correctly. There have been numerous examples where this has been exploited. As such, the reforms will transform Companies House from being a passive administrator of information to being an active gatekeeper and ensuring accurate and reliable information is entered. The main methods in which they will achieve this is by giving them a legal basis to query the information. And there are a few key points to this. There will be no grandfathering rules, so it will apply to new and existing information. It is discretionary, so they are not obliged to check every single record. It will take a risk-based approach to identifying which ones to check. A key outcome is to prevent dubious information getting on the register in the first place. They can ask for further details and proof before allowing it onto the register, rather than allowing it on and then having to apply to have it removed. Another area critical to these reforms is identity verification. It will be mandatory to have at least one fully verified natural person for a company on the register. And it expands out to cover anyone filing on behalf of the company, all new and existing directors and all PSCs also. This is a huge leap forward in terms of removing anonymity and safeguarding the quality of the information. The full details are yet to be revealed, but they hint it will use existing technologies to compare ID documentation that contains a photo along with a live photo or video of the person. And that will then use biometric technology to confirm it's the same person and also check the validity of the document. Approximately half of all companies formed are done by formation agents or company service providers. So to close the loopholes, they call out that these trust and company service providers will need to register with Companies House and be supervised in the UK or prove they are supervised by an equivalent AML body. And these providers must also conduct the ID and verification to the same standards that would be applied if forming a business direct. And Companies House say they will request evidence of these checks to ensure an agent's process is robust. So in summary, some really big changes that will increase the availability of UBO information via the new Register of Overseas Entities, and also to provide full confidence in the data at Companies House that so many institutions rely on in their due diligence procedures. Thanks for listening, and if you have any questions in these areas, please contact us using the details on screen.